You're live, Madam Chair.
And welcome back, or welcome, folks. It's not welcome back, it's welcome. It is Tuesday, February 28th. This is our first meeting of the week. This is House Corrections and Institutions Committee. We're going to be starting off our week working on the governor's recommended language in the appropriations bill on two issues that we've been looking at. One is the repeal of the home detention program within the Department of Corrections, as well as looking at absconding from community supervision for a person who's on furlough. There needs to be some clarifying language for that. Ben Novogrodsky, our legislative counsel, has been working on a proposed language, and this before us. We do have paper copies, and that's also on our committee webpage. This is language that Ben has worked on with the possibility of us making this recommendation to our appropriations committee to include in the big bill, the appropriations bill. Doesn't mean it will get there, but this could be one of our committee recommends. So Ben, I'll turn it over to you, and if you could walk us through the language in front of us would be great.
Thank you, Chair. I'm Ben Novogrodsky for the Office of Legislative Counsel. As you spoke about, this is what we'll affectionately refer to as orphan language for the budget, potentially. And I want to ask, we want to discuss the sort of the absconding items first, which probably will require less discussion.
Do that.
Okay, so we'll jump there then. So if the committee will turn to page 7. So you'll see that absconding is now defined in section 722 of Title 28. And this is what I referred to last time of sort of it's really a new home for the absconding definition that lived in section 724, which was community supervision, furlough, revocation, suspensions. It's just a more logical place for it to live in the definition section of the subchapter. The definition remains the same as it did in 724. It also moves the technical violation definition from 724 into 722 as well. Again, logically, from a statutory perspective, it makes sense to just keep all the definitions together that govern the subchapter. So that's what you'll see in new subdivision 1 and new subdivision 4. If you turn the page on page 8, you'll just see that technical violation in 724 has been struck because it's been moved. Same with the absconding language in subdivision 3. And then finally on page 9, this was the initial language in the budget request where section 808E now includes absconded to mean the same as absconding as defined in 722. And then keeps the same deletions and additions in subsection B that were suggested by the department.
So we didn't make any change to, if you look on page 9, 808E, B. That is what is in the governor's proposed appropriations bill. It just clarifies taking out those sections that some of it no longer exists. It's cleanup language. As we were going through this last week, it became clear that we probably needed to clarify the definition for this purpose about absconded, because there was no reference in this particular section to the definition of what absconded really was. So Ben recommended that we define it for the purpose of 808E. Did folks follow on that?
Yes.
So it's a lot of additions and subtractions for a really simple, quick change, but that's just the nature of legislative drafting, I suppose. After my talks with representatives from DOC, Mark Devins and Dale Crook, it appears that there was no opposition to this change and for the meaning to be the same as what was previously defined in 724 if this bill were to go through.
Okay. So we have Mark Devins online. We also have the commissioner of DOC here. So before we move on to home detention, Would DOC want to weigh in on this at all? Would it be you, Commissioner, or?
Unless Mark has something to say, I mean, I think this makes sense to us and perhaps just to clean up some of the language.
So it's just clarifying, it's defining absconding, and then it's making a reference from 808E back to it. So where's the committee fine with this?
Just one quick thing.
Okay.
Forgive me if I'm off on this, but under the technical violations in section 2, it shall be abuse of the department's discretion. Is that word correct? Abuse?
Yeah, so this was the subject of
Current law.
a lot of debate from
Current.
last year.
Okay.
It's current law, just about the standard of review for court review of department revocations and suspensions of furlough.
That's your 90 days.
Correct.
If it goes beyond 90 days to house someone for a interrupt in their furlough status, then it's an abuse of the department.
Thank
If I
you.
may.
Mhm.
So we spent, the Department of Corrections and the Defender General's Office and a few other stakeholders spent a robust amount of time last year negotiating out these provisions. And this was the consensus agreement that we reached on balancing the needs of the department with the needs of defendants who would be subject to furlough revocations. And so our preference would be to keep it the same. In so much as
Please.
it was a lot of work went into crafting the technical violation stuff under consent.
And if you look further down, this is current law. If you look further down, it is considered to be an abuse of the department's discretion if the furlough interrupt is for 90 days or longer, unless, and then you look at 1, 2, and 3. So unless the offender's risk to reoffend can no longer be adequately controlled in the community, the violation or pattern of violation indicate the offender poses a danger to others, and the offender's violation is absconding from community supervision. If those three situations, if one of those three situations occurs, then it is not an abuse of DOC to hold longer than 90 days. That's how the language operates.
No, thank you. I just was asking for clarification on it. Thank you.
Anything else?
No, not.
Okay, let's go to home
And then we
detention.
still have our battle scars from that.
Yeah, we're not gonna reopen that. That's about 2 years worth, that's about 2 years worth of work
Yes.
on that.
And a consensus agreement that every party got to, I think everybody walked away happy with that. Now, nobody got everything they wanted. Some people got, parts of what they wanted, but I think it is a good, and it's only been in place a year, so it's
Give it
good
some
to give
chance.
a little time to.
I think the definitions are good.
Okay, let's go on to home detention, which then gets into the statute that pertains to bail, which is beyond our jurisdiction. That is House Judiciary Committee.
It is. So, given the committee's discussion last week, and not wanting to take away a tool, I conferred with the judiciary, the Department of State's Attorneys and Sheriff, the Defender General's Office, and the department to try and come up with some language to try and, and it was really difficult to not do away with the tool, but make it more usable in a way without really broadening its scope. And, I think essentially what this does is that it does add home detention as a condition that can be placed on the defendant at arraignment, either as a release on their own recognizance or pursuant to unsecured bail. But what this essentially does is that it gives prosecutors and defense attorneys this tool at arraignment to do it. What it did not initially do, but what this does address in the separate portion, is what to do in that interim time while the department is investigating the suitability of the home detention residents. And so what this does, this specific section, so I'll go through it more line by line, but if you look in the middle of page 6, what is added to the home detention program under 7554B is that prior to the court's receipt of the department's suitability report pursuant to subsection B, of this section, the court may order the defendant released pursuant to section 7554 of this title. So what this does is that someone can be released on conditions before the report is received and a decision is made on home detention by the court. So this is a new wrinkle in the home detention equation, if you will. And it's ultimately a policy decision for the committee if this is something that the committee wishes to pursue. You know, from my understanding, talking with the department and the various stakeholders, is that most people that are subject to home detention right now are there either for some form of assault or you know, a drug crime with deaths resulting. So they are more serious allegations than many people that are currently subject to being released on conditions. But what it would also do is that this is another tool for the court. It also may help with the resource issue that was raised by the department, because currently right now, under 7554B, the department has the authority to go out and bring people back in that violate the home detention program. What this would potentially do is also add local law enforcement and state police, which often enforce violations of conditions of release, and give them the ability to pull people back in if they violate it as a condition of release. So there may be some resource assistance, but ultimately I would leave that to the department and to the courts to really opine more on that possibility. So to just go through a more line by line, now that there's sort of been that high level view, you'll notice on page 1, there are just a few changes to make pronouns more gender neutral. So you'll just see that there. On page 2, you'll notice a repeal of subdivision G. That was the community-based electronic monitoring program that was referenced before.
So I just want to make sure.
Sorry, I have the wrong, I thought I had the bill, but it's not, I have a printing, but it's not the right one.
No.
I'll pull it up on my computer.
Is there another copy as well?
I don't see any.
There were
other printed
5 copies unless I pulled something off the printer that didn't belong to us.
Yeah, no, this is some other.
3.
Yeah, one
You can watch it there. Okay, all right, sorry about
Okay,
that.
one, that's what I was thinking of.
Oh, really?
So let Michelle get a little settled here. So I'm gonna backtrack just a little here. So the question is for home detention. What happens when the person goes to arraignment and they will have bail set, right? That will trigger an automatic look-see if the person qualifies for home detention, if it's a good fit,
Yes.
correct?
Yes, but also this now adds home detention as a condition of release that can be imposed without bail.
Without bail. So we're changing it a little bit because right now, current statute is home detention is only available to those who have bail set. So this broadens the home detention program to include not just those who are on have bail set, but also for those that do not have bail set, correct?
Right, but that would just be for that period of time, because ultimately, while it could be a condition that's issued at arraignment, it would have to be in accordance with the home detention program, which requires bail as a precondition.
So that's where I'm getting mixed up. So why would it be available for someone who does not have bail set? Because they would automatically be going into an incarcerative setting, or they could be released without bail.
So, talking to the prosecutors, this was actually viewed as a positive, because what it could do is potentially help with the speed with which arraignments are disposed of. So it doesn't necessarily solve all of the equity issues that the committee was concerned about, but what it could do is that for those that had a private attorney, they could potentially stipulate to home detention right out of the bat at arraignment as a condition of release to get that process jump-started. And then ultimately the court would make the decision after the investigation was complete.
Whether to put in bail or not?
Right.
So so home detention would be a condition of their release. So they would be released, but they would have to be within a home detention setting. Where would they physically be sitting?
So at that point, before the investigation could come back, this would enable them to be released, and that's that section that I referenced on page 6, is that they could be released prior to the report coming back during that, and that's a 7-day time period where the department has to come back with the report within 7 days of the request.
So there would be, I'm just trying to
It's
clear, it's complicated. So they would be released, but home detention would be a condition of that release. But they haven't been approved for home detention yet.
correct.
So where would they be housed? Where could they go? Anywhere?
They could be released on their own recognizance with certain conditions. So they wouldn't necessarily be in an incarcerative facility. They
Right.
could be.
So then, if they're out in the community, supposedly they should be under home detention, but that hasn't been accepted yet. It's a condition of their release that's pending, really.
Mhm.
And then they have other conditions out there. And if there's any violation of any of those conditions,
They
and a
could be
violation of home detention, which they haven't been approved for yet, which is the question that I have. But any law enforcement could then violate them and bring them back.
correct. And really what it does is it combines the dual purposes of 7554, which is to prevent risk of flight or to mitigate risk of flight, and also that public protection aspect. So you order home detention as a condition in combination while that investigation is pending. It's meant to provide that level of mitigation risk of flight, but also the public protection aspect as well.
Michelle?
Yeah, I'm a little perplexed by this. I feel like what we were talking about when we heard about home detention and if it should stay or if it should be removed, the concern of many members of the committee was that basically some people have bail, they aren't able to pay their bail, and therefore they end up incarcerated instead of going to home detention, which to some of us seems like a better alternative. So my impression was that the new version was going to address that issue. This, what you've been talking about just now, is a different issue, and people who are held without bail, who have committed a higher level of crimes that aren't eligible for bail, I guess
They're not subject to this. If they're held for 75, 53, and 53, that still remains 55, 53, and 55.
So some people would still be held without bail, period. It's not, it would only be the 7 days you're talking about. It might take that long before the amount of bail would be set.
Correct.
Okay, all right, now I understand. Okay, all right, sorry, no, just, I got it now, but
So if bail was not set in those 7 days, what happens to that home detention condition of release?
It could be revisited.
It could be, maybe. Chip.
So the judge could release an individual on strict conditions of release that would be similar to those that would be imposed by the department on a home detention. In other words, restricted residence to residence, released to the custody of a responsible adult. Number 4, there's a whole list of conditions that could be set that would be similar to the home detention.
But the home detention conditions are not set by DOC. They look in terms of the appropriateness of housing.
This
But
is in
they're
the
not-
interim I'm talking about.
No, but the current home detention.
Right.
DOC does not set the conditions
Correct.
for home detention
Right.
currently. The only thing DOC does is look to see if there's appropriate housing. That's it, because the defendant is under the court. They're not under DOC. So any conditions that are set by the courts for that defendant are set by the court, and home detention is a condition of their release. Could the court then do, as Chip was saying, put in some stricter conditions around the home detention?
Yes.
It's not DOC doing it, because they're not under DOC.
And really, the mechanism by which home detention, it's really the same, because it's all adjudicated by the court.
Right.
So if anything, it keeps it within that structure.
What I was saying was that in the 7-day interim, when the court has the ability under this new section to release the individual into the community, they could be released on terms that would be similar to home confinement. Again, a responsible adult, living situations, restrictions as to travel, and to where to go and that sort of thing. I was talking about in the interim, so that the court can be assured that, okay, we're going to set these strict conditions so that in the event that this individual is qualified for home detention, then these conditions will likely secure that individual in the interim in the community, rather than set bail.
So at the end of that 7-day window, say the person was released, they're waiting to see if bail is going to be set or not. Is DOC going to be looking to see if there's adequate housing?
That would be dependent on the judge's order, but theoretically, let's say that at arraignment, it was requested. The judge then says, okay, DOC, investigate. That would start it at arraignment, and so within 7 days, they'd have to finish the investigation and send it back to the court for the court to then decide.
So there could be a couple scenarios that one, bail is not set, but there's not adequate appropriate housing for home detention. So then what happens?
Well, if there's not adequate, if there is,
DOC finds that there isn't adequate housing.
so if there's no bail set and DOC were to find that there's not adequate housing, I actually think it would help the situation, because A, if there's no bail set, then they wouldn't be eligible for the home detention program, and so not having housing kind of makes the issue moot.
So that home detention condition of their release will be taken away?
Yeah, it could be revisited, and that's, upon my conversations with the state's attorney's office, that would be something that they may request themselves, because it's a condition that can't be met. One thing that dangerous thinking on the fly sometimes, but one thing that this discussion has made me think of is that since it does appear to cause some confusion, which is not the intent of this, it could potentially be removed from 7554 altogether, with their language remaining on page 6, where prior to the court's receipt of the department's suitability, the court may release the defendant pursuant. So basically it will say that, okay, if it's requested at arraignment, you can release the person subject to conditions under 7554, and then make the determination once the the report is back. But I would like to hear the court's, Judge Zonig weigh in on really just the practical impacts of that. In my view, this was sort of a belt and suspenders view of it, to just cross-reference the two statutes to make sure that they can be used in tandem, and that the court had the flexibility to release somebody with other conditions to protect the public and mitigate the risk of flight while the investigation was pending.
Questions of the committee?
Mine's a new way.
Pardon?
Mine is a new question, a new line of questions.
Not pertaining to this at all.
Well, pertaining to home detention, but not.
Okay, I know, this is so confusing in terms of what is your question pertaining to home detention?
I have some questions specifically around electronic monitoring.
Okay, well, we're gonna get there because there is a change in language there. So why don't we go back to section 7554? Okay. And we already did page 1, we're on page 2. Because there was this clarifying language on that, just making it more, instead of him or her, or his or her, it's the person and the defendant. It's just clarifying. Okay. So page 2, you've deleted and you've added.
So the deletion was at the suggestion of judge zoning. And it makes sense just from a statutory perspective because the community-based electronic monitoring under 7554D expired in 2018. So that statute's on the books, but the program isn't actually operable. So that's why subdivision G is removed on page 2 and then subdivision F on page 3. It's really just a statutory cleanup. And then H on 2 and then G on 3 adds home detention as a condition of release as long as it's in accordance with the provisions of the home detention program.
What is section 75B?
That's the home detention.
That's the home detention, okay.
7554.
Yeah, 75.
Yeah, I should say little b, not subsection b.
So that's where we make it a condition of their release. Either with bail or without bail, right? Okay. And then for the committee, that then kicks in for page 6, little e. That's how it tracks. One is in the section that pertains to the court, bail and no bail, and then the other one's in the section that deals with the home detention, and it's a cross-reference to 754.
Yes.
Okay.
And then with 754 little b, so on page 6, there was the addition, this was at the request of the department, to include the use of passive electronic monitoring in addition to the appropriate means of surveillance and electronic monitoring. And I will defer to the department on what passive electronic monitoring is. So I don't know if
It's not real time. A fact will, something, a violation would occur, but they may not pick that up for a delay of a few hours or a day or something, and then they can intervene. Active is real time. They see a violation, they can act right now. Passive is there's a delay. And that, I think, is to help with staffing issues. That's what I was understanding.
and that was the rationale, was that it would help with the staffing issues that were raised last week.
So, Troy, is your electronic monitoring question related to any of this?
Well, it's a bigger.
It's bigger. So maybe it's more appropriate to wait for DOC to be at the table? Or
Well, it's
Ben?
court appointed, right?
It's
This
what?
is still applied by the courts. This is still applied by
Right.
statutes. Electronic monitoring is a condition of this statute.
Right.
And I guess I just want to start the conversation with a can of worms. The only difference here for people who are subject to the conditions of electronic monitoring are that they were unable to pay bail. So somebody who could pay bail is then released and are not subject to any sort of electronic monitoring, right?
Correct.
Yeah, and that to me feels like an equity issue. That the only people who get an ankle bracelet are the ones who can't afford bail. And I'm wondering if if we're messing around with this statute, I wanna maybe see if there's a way we can put that in as an option, but not a requirement.
I think that is a House Judiciary issue more so than here. Because bail is really in the jurisdiction of House Judiciary than us. We're DOC. We're not the Committee of Jurisdiction that deals with bail statutes. That's where this is kind of,
So is
it's kind of iffy right now. So Michelle?
I was gonna raise a similar point, and I understand the jurisdiction issue is complicated, but the truth is that this program of home detention is under our jurisdiction, so maybe it's a gray area where we both weigh in, but I was actually thinking exactly the same thing. I mean, one of the concerns we heard last week when it was recommended that we repeal home detention as an option is that this is a burden and it's causing stresses on staff who need to come in when there's an electric monitoring violation. But the only reason that we have the problems with the electric monitoring is that some people are being subjected to that and other people aren't. You know, if I commit a crime and I can't pay my bail, I get an ankle bracelet. And somebody else who commits exactly the same crime, or maybe or not, while they're waiting their trial, they don't. And it just, to me, it feels very strange that we're putting additional surveillance on people. And the only reason, it's not because, like, I would be okay with additional surveillance if it was because there was an additional risk for some reason. But that's not what we're doing here. We're exclusively doing it because somebody can't afford to pay bail. And that seems very strange. And
I think we have to take a step back. Bail is put on for a risk of flight.
Only.
It's a risk of flight, and I know people feel, well, some folks can't afford it, so therefore they can't pay bail. Bail is set for a risk of flight. If someone is a high risk of flight, and the court feels, yes, they could wait for their trial out in the community, but there's a risk of flight, bail is set. Because there's a risk of flight, you need some way of monitoring and keeping track. So that's why the electronic monitoring bracelets. For those folks that maybe have committed the same crime but are not a risk of flight, they're going to show up at their court date. Bail is not set because they don't need to be monitored to ensure that they're going to show up to court. We have to get back to what bail was actually there for and not get into these nuances where they can't afford to pay bail. Some people can afford to pay bail and they refuse to. I think we have to be clear about that. Some folks can't, but we've done a lot of bail reform over the last 5 or 6 years. And I think we have to be cognizant of how that changed, or maybe didn't change, but how that changed how people are put on bail or not. That's in the Judiciary Committee that did all that work. So if you go back to why bail is set, if it's set for the risk of flight and they're waiting for their court date in the community, there needs to be some mechanism to ensure they show up.
And really, when you think about it, so yes, Chairman, you're right. Bail is purely in isolation about risk of flight. And there are factors that could be considered in that. It can be whether the person has ties to the community, whether or not they have a history of criminality, a whole bunch of things that go into that analysis. What home detention kind of takes it to the next step is that, okay, well, bail could be set, right? And then what home detention does is that it combines that purpose with some public protection factors as well. And Judge Zone testified to that. And that's why home detention could be an option for those people that wouldn't otherwise be available because of that public protection analysis that goes into that statute. Another thing to think about is that this addition in 7554, not little b, just 7554, is that could then be part of the analysis for conditions of release in general. So it wouldn't, necessarily be contingent on bail to at least be considered. It may ultimately start the process like I was talking about before, and then whether or not bail would be decided would then kind of prompt whether the person would be eligible for the program. But it could jumpstart the process, if you will.
So we have some more questions. Chip and then Tristan.
So I have a question on a different section. On page 6, a defendant who is on home detention shall remain in the custody of the Commissioner of Corrections with conditions set by the court. Commissioner, does that mean that those folks are getting credit against their sentence while they're on?
Yes.
Okay, very good.
And that you can't see it here, but in subsection D of 7554B, it outlines
Specifies,
that.
okay.
So a person who is out in the community and not on bail do not get credit for
That's
time
correct.
served.
That's right.
Every detainee that is incarcerated, whether they have bail or not, for every day they're a detainee,
Good credit.
gets credit to their eventual sentence. So if they're held as a detainee for 2 years before they go to trial, and then their sentence is 10 years, 8 years is left to serve because they've already served 2. They're on home detention and they have bail. The same applies. Credit for each day served.
It's essentially an incarcerated condition. So you're considered incarcerated during the time you're at home detention, despite the fact that you're out of an incarceration.
Wasn't there a court case in Vermont in which that was argued and it got denied? Meaning somebody argued to have home detention as time served, and the state, I believe that, I'd have to go back and reflect, but I'm pretty confident it was a court case out of Vermont in which the Vermont Superior Court said no and didn't count it towards, what do you call it, as it wasn't as time served.
I'm not familiar with the case. I'd have to look into it. It's also possible that the statute was amended after that was handed down, but I can't say for sure.
No, the only reason because the statement that I was like, whoa, wait a minute, I don't want something to be shot out that may not be the case.
Today, for the individuals who are on home detention, each day that they're on home detention counts as a day towards their.
Okay. All right.
Tristan?
Almost set.
So where are we, folks? This is proposed language. Right?
And the other aspect to all of this is that there is a sunset of these. So the home detention program itself would be repealed on July 1st, 2025. So what that effectively does is that force the legislature to come back and revisit the validity of the program. 7554D is repealed altogether for the reasons that we discussed, that the program is essentially defunct. And that those specific provisions in 7554 that cross-reference home detention will also be repealed on July 1st, 2025. So it's essentially a package that gets repealed at that time to have the legislature revisit it and revisit the policy.
Any further questions of Ben? Because I do want to allow time for DOC as well as our state's attorneys to weigh in as well. Any further questions of Ben on the proposed language? Thank you, Ben.
Stay here.
Wherever you're comfortable. I think you're going to move, right?
Out of a lot of fire.
So do you want to come on up, Commissioner?
Yep.
And then we'll do the state's attorney next. Welcome. And I know the DOC is coming from the point the governor's recommend was to repeal home detention. Okay? That's the administration's proposal. It's in the appropriations bill. When we first looked at this last week, the committee was saying, wait a minute, we're not comfortable with repeal. Let's see if we can make home detention work a little bit better. Have it at the court where they have to look at it at the time of arraignment, and do a sunset so we can do another review. So we understand what the administration is looking for. So with that said, Commissioner, we have a new draft.
Great. Well, good afternoon again. My name is Nick Demo. I'm the Commissioner of the Vermont Department of Corrections. So just backing up to the chair's statement, I mean, in the governor's recommend, we asked the legislature to repeal the home detention statute. And there's a couple of reasons for that. This program, as it's currently configured, is extremely onerous on the department. In part, that's because this is the only supervision program that we have that occurs before somebody is sentenced. So the Department of Corrections does not play in this space otherwise. But the legislature, in creating this, I think, had the intention that we needed a hybrid program to balance, as Ben was saying, balance the bail need, will the person show up at court when they're required to, but also look at the public safety aspect of this. And really, if you go back and read the legislative intent of home detention and read this Vermont Supreme Court's interpretation of the program and what its intent was, the goal was to draw people out of the incarcerated setting into their homes. For folks who weren't being captured under the bail statutes, but kind of either isolated acts of violence or some strange set of factors the state felt they could be reasonably supervised in their homes versus in an incarcerated setting. That was 2010, 2011, I think. A lot's happened since then. The home detention program did not actually achieve those goals. It was not the program that drew people out of our incarcerated settings. But a lot of our other work did. So the justice reinvestment work, a lot of the bail reform that the chair mentioned, did draw down our population counts, and you've heard testimony on that earlier in the session. So today, the program serves 9 people in the state of Vermont. It is extremely onerous, it's costly to the state, and those aren't necessarily reasons to get rid of it, but it also puts the department in an awkward position where we're servicing one pre-sentence need that we're not well equipped for. Our field offices are not 24 hours a day, 7 days a week. We don't have an emergency response capability to respond to a violation of the system. For example, nobody can call 911 and say, send a corrections officer, the person is violating their home detention. There's no option for that. What happens is we do electronic monitoring, they get a call to the district office, the district manager then notifies staff who are familiar with that case, who then try to understand, okay, what happened? Did they cut it off? Did it die? Which happens. I mean, these things are battery powered. Is the person going to commit another act of violence? And if there is a perception that violence or another crime is going to be committed, then we call the police. Because our probation and parole staff, while they have arrest powers in very specific circumstances, are not law enforcement officers. They don't go out and arrest people in the act. So while we talk about kind of passive and active electronic monitoring, both are just different forms of passive monitoring. One's much more labor-intensive. So anyway, that is the context of why we asked for this to be reviewed. I think on balance, we felt that the program wasn't probably functioning as well as it could have. But, we heard from your committee last week that there is interest in continuing the home detention program, and certainly we respect that and understand where you're coming from. I think some of the changes that Ben made in this draft are interesting, and we could work through some of that. There probably needs to be some tweaks here and there. There are some parts that the department can't support, and I'll start there, I guess. I think this oops, stop.
I just need some clarification.
Okay.
We just heard very clearly, as I was asking my questions before, that bail is only used to contain risk of flight. You're bringing in risk to community and risk of further acts of violence into the conversation. Now, that doesn't feel...
So that comes from the home detention statute. So bail, you're right, and really Judge Zone is the expert on this, so I will defer the expertise to him. But bail is exclusively focused on whether somebody will come to court. But the way the home detention statute is written and how it's been interpreted by the Supreme Court is the legislature intended to create a hybrid system that looks at that bail component, will you come to court, and what is the risk to the public? And so that was new for Vermont, and we don't have any other criteria that work quite like that.
But risk to the community is not a factor when assigning bail. Is that accurate?
Yes, but it is a factor when assessing whether somebody should be released on a home detention condition.
I thought we agreed though that was negated when, right, we're hearing kind of both sides of this coin, and it feels really disingenuous to me.
So,
and maybe I'm not understanding something, but if bail is only applied to contain risk of flight, and it wouldn't be applied if somebody were a risk to the community, why are we suddenly talking about risk to the community after they've been assigned bail?
As part of Ben?
Yeah, well, so the legislature decided in the past that home detention for those that couldn't make bail would be the alternative, and that it combined that if you were eligible for bail and you couldn't pay it, then you could, rather than going back into prison, you'd go into the home, and there would have to be a public risk analysis associated with that. So that was a decision that was
redundant, doesn't it? Wasn't that risk already taken care of when they decided to apply bail?
No, because that's not part of the bail analysis.
Right. So bail is just whether or not you're going to come back to court, and then the home detention program works in that other public protection factor into it. So if you're eligible for bail, but you couldn't pay it, rather than just going back to prison, you could be released back to your home, but you'd have to ensure that there are certain public protection factors to qualify.
I remain confused.
So the home.
Hold on.
Okay.
Is it possible for somebody who is deemed a risk to the community to receive bail?
Yeah, certainly. It would only, that analysis turns only on the question of whether you will come home. There is no analysis in the bail, in determining bail, about whether you are a threat to the community.
Okay.
But there is when considering home detention.
And when someone's
So
on
it's
home,
essentially kind of a.
but when someone's on home detention, they are really under the custody of the Commissioner of Corrections.
Correct.
For that home detention piece. When they're out there on bail and no home detention, they're not, are they under the custody of the Commissioner or not?
I'm sorry, can you ask that one more time?
When a person is out on a home detention status
Yes.
with bail, they're under the custody
Correct.
of the Commissioner of Corrections.
That's right.
When a person is out on the community
Under just a condition of release.
under a
Or
condition, they're not under the custody
They're
of
not
the
under
Commissioner. So that's where your risk factor, is that where your risk factor kicks in? Because they're under the supervision of the Commissioner of Corrections. And that's why they can, if you look at what they have to look at for conditions of home detention is that the court needs to consider, because it's a home detention is part of their conditions of release, the court has to consider the nature of the offense, the prior convictions, history of violence, and any risk or undue burden to other persons who reside in the proposed residence.
So to answer your question, I mean, the way the home detention statute is written, it says that the court, in placing a defendant in home detention, will be reasonably assured of his or her appearance in court. That's where bail would stop. And then that the proposed residence is appropriate for home detention, and that creates then a criteria in which the court should evaluate their risk to the public.
Okay. So
And
then
that's unique only to home
my
detention.
next question then would be, is it possible for somebody who is deemed to be a risk to the community to be assigned home detention?
Only if the court felt that home detention sufficiently protected the community from whatever risk they presented.
Okay.
So yes.
Okay. Thank you.
Chip?
So what we haven't really spoken about here, Troy, is that the court can impose cash bail to assure security and return to court. But in addition to that, they can impose conditions of release along with bail. So oftentimes you find a nominal amount of bail set maybe, but conditions that would, again, be toward protection of the community. They are two very separate things, but the court can do that on their own initiative. They don't need home detention. So they can, again, demand that a person be released to, that's a way to actually, judges have told us in the retention committee, a way to get defendants off the street who pose a risk is to have them released into the custody of a responsible adult, because oftentimes that won't happen, and that will generate incarceration. So the conditions can be set in addition to bail, so that you are combining return to court and safety of the community, and it can be imposed by the court.
I mean, I think a salient example of that is if you were charged with habitual driving under the influence, the court could set a condition saying you can't drink alcohol, because that's the real predicate to the risk. And they could set a $20 bail to ensure you show up for the court. So that's how home detention differs.
Can you hold on here a minute, Ben?
Yeah, and
Time's 10.
the commissioner makes a good point. I mean, when it comes to a DUI case, that's pretty routine, that one of the protective factors would be you can't drink, you can't possess alcohol. But if you look at 7554, I mean, subdivision 1 on the first page really talks about it, and this is my fault, I should have set the stage a little bit better. That they may be released on their own recognizance or upon the execution of an unsecured appearance bond and are not specified by the judicial officer. So that's that.
Where are you? On page 1?
On page 1, subdivision 1. So they can set a nominal amount that will, that determines that the release will not reasonably mitigate the risk of flight. And then in determining whether the defendant does present a risk of flight, they consider, in addition to any other factors, the seriousness of the offense charged and the number of offenses for which the person is charged. So that's a bail consideration, right? If the officer determines that the defendant presents a risk of flight, the officer shall, in lieu or in addition to the methods of release, impose a least restrictive set of conditions. And that is what follows in A through F currently, or A through G currently. And so that would be the home detention that Representative Troiano referenced, whether or not you participate in drug and alcohol screening, the execution of a secured appearance bond, so paying a little bit of money, a surety bond, impose any other condition found reasonably necessary. So at arraignment, it's very routine that the prosecution and the defense will either stipulate to certain conditions of release that may happen in a DUI case, or for the judge to assess the case individually, which he or she would do anyway, and impose additional restrictions that maybe were not stipulated to or just are warranted given the situation.
So I think one important thing to call out from what Ben just read is, for conditions of release, the court must use the least restrictive condition. The thing to remember about home detention is it is the most restrictive release condition. So when you're a judge evaluating whether home detention is appropriate, the folks that you're considering, that population is extremely slim, because you're up against, why would I set these conditions unless they presented a real threat to the community? And if that's the case, why are they not incarcerated? Why are they not held without bail or held because they present that threat? And so what we see in practice is the populations judges are considering for this are unique, which is why it's such a small number. And I think Defender General Valerio can talk to you more about that. But to give you a sense, I mean, the folks we have on home detention today are charged with attempted murder, sexual assault, unlawful restraint, aggravated domestics, and really, really serious crimes. They may be isolated, or the victim may be one person, which is why they don't present a broader threat to the community. But there just aren't that many people that fit in this space that the judges would feel that these conditions are appropriate, because they're extremely restrictive, and the judge needs to look at the least restrictive need.
So by having home detention as a condition, it is almost going against that least restrictive, because it's one of the most restrictive, because they're on electronic monitoring and they have to have appropriate housing. And there may be conditions set for around the home detention itself.
And there almost always are. I can't say always, but almost always.
Michelle?
So there are people who can't pay their bail, who are waiting for their trial, who haven't committed violent crimes. I happen to know some of them who have written to me. I have had calls from people who that is their family dynamic. One of them is sitting incarcerated right now. And I have others in the past when I worked at the Community Justice Center that had long times incarcerated, 4 months in one case, for somebody who had a misdemeanor. And when it was time for his trial, they said, oh, the maximum sentence would have been 60 days, you're done, you got to go. So it seems like the possibility of home detention, while it is restricted and not ideal, I think most people would agree it's preferable to being incarcerated if you don't have the ability to pay bail. So what I'm wondering is why, I mean, I think we talked about this last week, was why doesn't DOC use it in other cases for individuals?
It's not within our discretion.
Or why doesn't judiciary? Then why doesn't judiciary? It sounds like judiciary has been underutilizing it as an option.
I think this, I mean, I'm a lawyer, but I'm not, I'm not functioning as a lawyer today.
Yeah,
But I will step a little further out there
Yeah.
to say, I think the tension that you see is that it's so restrictive as a condition that it's not appropriate, probably for somebody with a nonviolent misdemeanor. It's too restrictive.
but
So
being
the-
in prison
there's-
is less restrictive than that?
Well, then herein lies the rub, is they're in prison because of bail, not because of the public safety question. And so the court is saying, you're in prison because I, the judge, don't feel that I can assure your appearance without setting bail for you, and that person can't afford bail. And that gets back to the equity question, and I really don't know how we resolve that. I think that's a really complicated issue to dive into. But home detention isn't, I think, the alternative. It's actually on the bail side. Because there are other conditions, so I'm not sure what this person was charged with, but I mean, I assume there are less restrictive conditions that could be set on that person that aren't home detention.
But maybe there was a history to that person previous to that misdemeanor that we just don't know about.
Right, and it's hard to look at the individual cases, and also that, judges are people too, and so there is disparity in the system, and we want to work through as much of that as we can. But my point to you all, I guess, is to say, I understand, I agree with you that being at home, even if you're electronically monitored and you can't leave, is better than being confined in a prison. I don't think home detention is the solution. I think the actual solution to the problem you raise is somewhere else.
The one other point that I want to just add to this is that if we think about in terms of our incarcerated facilities and replacing them hopefully with better incarcerated facilities, we talk a lot about what is the appropriate bed number. So like yesterday I visited the Women's Correctional Facility, and I believe she said 60 women were there as detainees. And there was 40 something that were there that were sentenced. So 60 people that's a lot of people. Now, some of them have, transitional things and they won't be there very long. But when we're looking at numbers, if we had more people in home detention, yes, it's restrictive, but is that better than keeping half of the population in a prison? I don't know. I'm just raising the question.
I would say possibly.
And for future placements, should we think about if we utilize that more readily, maybe we wouldn't need to build something quite as big as what has been talked about.
Yeah, I think possibly you're right. I guess I would go back to my point, though, that I think we're actually not solving the right problem. We're just putting a different, a slightly better solution on it when there's probably better solutions that don't require this type of. This is extremely intrusive. Having an ankle bracelet on and being in your home, except for work or medical appointments or court, that's tantamount to an incarcerated setting, which is why I think the state set this up. But I would say, if you intend to keep this, and it sounds like you do, then I would keep it as a carve out for these very unique cases where the court has gone through its analysis and determined it makes sense for this individual, but not as a way to say we need to draw down and get these folks out, because that's actually, I think, a bail problem and not a home detention problem. And I know it's frustrating because there's people sitting there that you want to get out, and I do too, trust me. But I want to find the actual right way to do that, and I don't think, my personal opinion is that the home detention is not that. The other thing, I'm happy to entertain more questions, but I do want to talk about that first section and some of the changes in there.
We've got Ben that needs to clarify the interest.
Well, it might be related to, because what I was going to discuss is that, and this is speculation, so Judge Zone would probably be a better person to testify about this, about why it's not being used. I mean, right now it's a statutory restriction. I mean, this home detention can't be used unless bail is set currently. And then you go down the process. But what this would do by adding it as a condition of release is that theoretically, at arraignment, bail could be set. You could say home condition is set, or home detention is set as a condition of release, and right out of the gate at arraignment, the process could start. And so what it does is that it may expand that to give the court that tool, which may explain why it's not being done currently or being done more. But I mean, I think that you might have different opinions depending on who you speak to.
Tristan, and then we're going to, Wayne, Now we're gonna go back to the commissioner. We also had the state's attorney waiting too. So Tristan,
Commissioner, you said this program is onerous, time consuming for the department. And costly. Do you have any numbers on that?
So I don't have numbers with me, but I can give you kind of in broad strokes why that's the case. I mentioned that we're not a 24/7 outfit in the field. We are in our correctional facilities, of course, but our field staff are not 24 hours a day, and they're not, law enforcement kind of first responders. And so what this program requires us to do is any district office who has an individual in home detention, they have somebody on standby 24 hours a day to be the responder, to answer the phone, begin to start the process, call law enforcement, do all of that work. And one of the things you've heard a lot when we talk about staffing is for the field, the burden is the standby staff. And that's what's really the resource suck here. This program does cost money, and that money I think was removed from the budget a couple of years ago.
it's 200,000.
Yeah, in that neighborhood. So I mean, in the grand scheme of things, that's not an extraordinarily costly program for the department, but it does cost money. And it's really the configuration of having people on standby 24 hours a day to just in case one of the 9 folks in the state decides to cut their bracelet or violate a different condition somehow. So that's why the program is onerous. It was handed to us as if we were a system that did have that kind of 24-hour coverage, and we don't. Now, we currently are doing more of that. We have home detention standby, and then we have our hospital coverage standby, which you've heard a lot of.
So you've been handed a program that's underutilized. You're saying let's cut it. Sometimes a program that's underutilized could be scaled up and it might suddenly work. We've talked about all the limitations on that, but just speaking as a head of an organization, do you see a service to be provided here if you could get more people more bodies into this program?
Yeah, I hear what you're saying. I don't think scaling is the right solution. But I do think there are ways that we can make it less onerous on our side. So if the legislature's intent is to continue the program, I think there are some things that we could do to help with that. The scaling issue, I think, is going to be, again, really challenging because the number of people who would fit the mold for home detention is very, very small. And so I just don't know how we get to a scale. And certainly I don't think it helps us, that just adds burden. But if that's what you decide to do, certainly we will respond. We're just responsible for administering the program.
So we have a couple more questions. Wayne and then Troy. And then we're gonna go back to the commissioner to continue his testimony.
My whole thing from the beginning was if we could have over 400 people in detention, then there's gotta be some costs for each one of those people that are held incarcerated. And then the other issue, and so I was looking at the potential for cost savings there. At the same time, perhaps DOC is the wrong entity to be dealing with the people outside.
Used to be the sheriffs.
But if there was a cost saving, if the cost saving was significant, perhaps there would be enough money to stand up the ability for another agency, sheriffs or whoever, to be able to administer the program. And maybe
we went down that road.
some more of it. So I'd asked the question before, how much per day does it cost? Understanding you're operating a huge prison and some of those costs are going to be there, whether there's 0 people in there or 10,000, right? But there's got to be some significant cost savings per day for the ones in there. Is that cost savings per day, if you times that times 200, enough to pay for someone else to administer the home detention out there? But then the same question is, of those 420, we really haven't heard how many of those would actually qualify.
Yeah, and I think that number is pretty small. And as it's currently configured, I mean, you can make dramatic changes and perhaps drive that a different direction. I've said this before, I'm very reticent to use the number of like per person cost per year, but Isaac, is it in the 90s? 90,000, so I don't know what that works out to a day. That's how much it costs, how much it costs for an individual to be incarcerated in the state of Vermont for a year.
Per year.
So I don't, again, don't make me do math on the fly here.
But even 90,000, even if there's a half of.
They're all doing it. They're all doing math in public right now.
$260.27 per day.
How much?
$260.27. That's 1/365th.
But if
I think
they're in
you're
there
looking-
1.8 years on average, then, you know,
I
there's
think you're looking
there's
at a
some money
state
there.
bed cost first. When you're doing a cost comparison, you do it based on the out-of-state bed cost because the bed is being taken up by a detainee that would normally be, that bed would have been filled by an incarcerated person who's now serving down in Mississippi. So whenever they do bed cost savings, they compare it to what we're paying for an out-of-state bed for that.
So, I mean, if there's no potential for cost savings, and I'm with you.
There is a minimal amount of cost savings. And when this program was first put in place, it came out of this committee. And it was a tool to divert folks from coming into an incarcerated facility to begin with. And we had not done bail reform at that time. And also, there's been a lot of initiatives put in since 2008 under Justice Reinvestment 1 to prevent low-risk, low-severity of crime folks from coming into the system to begin with. So a lot of folks that were incarcerated 15 years ago are no longer being incarcerated. So the population that's coming in now is a much higher risk to reoffend and a higher severity of criminal activity. So your population has made a drastic change in terms of who is incarcerated, which then decreases the number of folks that might qualify for a program like this versus what would qualify 15, 20 years ago for this program. That's the systemic shift that has occurred over time. At one point, we had over 20 people, 25 people on this program back when it first started. We also had a sheriff in Windham County supervising out there, but the problem was not only was the person on home detention under the custody of the Commissioner of Corrections with conditions, but the sheriff started putting conditions on that person as well, and it really was getting out of hand. So we've gone through a lot of reiterations about home detention for this. So this isn't new. Troy.
It's kind of a hypothetical, but if the folks in the other rooms who are making decisions about how much money to give you decide to give you a good amount, money that you think would be an appropriate amount for doing the recruitment and retention that you want to do, where would this fall on a priority list, bolstering this program?
As a means to on our staffing front?
Yeah.
Well, I think I can speak for the entire field and say everybody would like to get rid of this program. But will that majorly move our recruitment and retention number? No.
So this isn't where you would prefer to put that recruitment retention focus. If suddenly you have, somebody says here, and you're like, wow, that's great, that's a lot of money.
Yeah.
I'm gonna do it all recruitment retention. This would be low priority.
I guess my question back is how would we spend money on this in a way that?
Well, you're saying it's onerous, and what I'm hearing you say is that it's tough to staff it 24/7. So let's take that away, right? Let's throw some money at that. Then would this feel like a better program? I guess that's what I'm asking.
No, because I think there are other ways to achieve those goals without spending the money here.
So Commissioner Continue your testimony.
So my only major objection to the way that Ben has structured this, and this is not about Ben, because I like Ben very
Don't make it personal, Ben.
purely professional, but is to say. is
One
to-
lawyer to another.
Yes, exactly. We're a small band, we gotta stick together. Is to say, let me back up for 1 second. The legislature created this program and said, the courts are gonna set all the conditions. The Department of Corrections will administer this program. And so your job is to determine if you can do that safely in the community, that a residence is safe. It's basically the primary question we're asked. And then, once it's determined that it is, and the person is put on home detention, we're responsible for monitoring. As this new draft is written, the period we would normally use to do our due diligence to determine if that's an appropriate place goes away. And so the person is immediately eligible to be put on home detention for those first 7 days before we've had the opportunity to do our due diligence on the resident. So let me give you a concrete example of that. I mentioned that several of the individuals who are on home detention today are in for aggravated domestic assault. So an individual is arrested for aggravated domestic assault of their spouse. They request to go on home detention, and that is approved for the first 7 days before the department has determined whether the individual is going back to the house where the spouse lives. Even if conditions are set that they're not to have contact with their spouse, they may have no alternative residence. And so I really bristle at the concept that until the department has been able to do its due diligence, we cannot appropriately supervise or administer this program. And so while that may result in somebody being incarcerated for up to 7 days on the front end, the risk of not being able to do our due diligence, I think, severely outweighs that. For the sake of the public safety, for victim safety. And so I'd ask that somebody not be eligible to be put on home detention until we have our period to do our due diligence on ensuring that the person can fit into this mold.
But couldn't the court put a condition that the person cannot go back to live where they were living?
Where do they go then?
Right.
And I think that's the confusion
That was
would
my
ensue
question.
immediately.
That was my question initially for those 7 days. If there isn't an appropriate housing situation, where does the person go? That was my question. Ben?
And to that point, so theoretically, yes, the court could impose conditions to try to protect against that situation. The one that jumps out to me as being the most appropriate would be the responsible adult condition. You place somebody, but typically what goes into that analysis is that you have to have someone, A, willing to be the responsible adult. The responsible adult themselves usually has to go through some sort of qualification. I anecdotally know of attorneys that have gone through this process, and the responsible adult that was willing also had a history of criminality, and so that was a factor that the court had to take into consideration. Ultimately, those obstacles may be overcome, but there is a possibility that there is no viable alternative for the offender to go to. A potential solution to this would be just to remove these additions that I've made to 7554. So home detention would no longer be a condition of release, and just leave the addition in 7554 little b to say that it could be released in the interim based on the rest of the remaining conditions. It wouldn't necessarily solve the problem that we're discussing right now, but it would at least remove home detention as a condition. Not to make it further complicated, but.
Oh, yeah, uncomplicated it considerably. No, I'm being serious. Use it as a tool, use it or don't.
But
I just don't want to
I
be
don't
the
think-
department in a position where we're being asked to supervise somebody in the community and we haven't been able to position ourselves to do that safely and successfully. And so I don't have concerns about adding it as a condition of release and getting courts to review this more often or in some other means to potentially bolster the use of the program. But I do think protecting that first period where the department does its investigation is critical to safely allow people to move into this program and remain in the community.
So Ben put out an option, and I do want to allow time for the state's attorney to weigh in on this too, because they're part of this discussion as well. So what Ben offered is not to make a condition of not to make a condition of someone being released with bail, not to have home detention as a condition of that, take that away. But to keep on page 6, for home detention program, that prior to the court's receipt from DOC about the suitability of housing and the person for home detention, that the court could order the person to be released according to the bail statutes, of which home detention would no longer be a condition, as Ben has proposed. So how does that make it more complicated? I think it doesn't make it more complicated, does it?
It might clean it up a little bit as far as the confusion. One of the thoughts behind putting that in the bail statute originally was to assist with the resource issue that was brought up, is that it wouldn't necessarily assist with the monitoring burdens that the department's raised, but it could assist with the enforcement side of it, because the department wouldn't necessarily be the exclusive enforcer of violations of the home detention statute.
For those 7 days?
Right. It could be local law enforcement, state police, whoever, because oftentimes, and I go back to the responsible adult situation, is that a lot of times law enforcement will just make random checks at the residence where the responsible adult and the offender is supposed to be, to ensure that they're there as they're supposed to be. So it would give another enforcement mechanism that might alleviate some of the department's burdens, at least relative to that.
So for a responsible adult to be cleared, is that done right then and there while the person's in arraignment, or is there a few days?
It can be.
That's a real policy change. We've got two policy changes here before us, committee. So right now, when a person is arraigned and they can be released with bail, home detention is not considered a condition of their release right now. The way Ben drafted originally, he did have home detention as a condition of that release. So what Ben has just proposed as a response to the commissioner's concern about those 7 days that they're out there and they're being supervised by a broader law enforcement, that something really could happen because there hasn't been an approved housing yet. Ben has then suggested we delete the section that he added that home detention would be a condition of bail. So we've gone full circle. And I don't know where the committee is, and the committee probably isn't sure where they are at this point either for this.
But to your point, Chairman, I do think that in a way that would make it cleaner. It keeps it just within the home detention program. And it just says that during that 7 days, you can have a whole bunch of other conditions that they're subject to, and those can be enforced by local law enforcement, and they can be brought in if they violate.
But the court could also say for those 7 days, they're gonna be incarcerated, right?
Good.
They could,
Yeah.
even though it's to the provisions of.
Right, and again, this is a subset of people currently, a subset of people that are subject to bail. And it's that. So the court still has that discretion about the availability and applicability of bail.
So just a little bit, on condition 4, there are occasions in which the judge will, the individual, the defendant will have someone with them in court that day, and actually the judge will interview that person and ask them if they are willing to take custody of this person and report to the court any violations that happen. Or it can happen later that day or the next day, but oftentimes it happens right in court at the time of the arraignment.
Okay, well, let's flag that, folks, because that's a policy shift back and forth. I think we also have to hear from the judge as well, Judge Zoning.
Yeah, I think it would be good, yeah, I agree.
Anything else, Commissioner? How about the passive electronic monitoring? Isn't that sort of a response to
Yeah,
the
that would
concern?
be, that clarification in the statute would help us on the staff burden side. I'm happy to talk about that if it's helpful, but that doesn't seem to be the most controversial parts of the changes here. That seems pretty low drag.
Alleviating staff burdens would be useful for us to hear if you can give us the super short version.
Sure. So the way we do all other electronic monitoring in the Department of Corrections is basically that the electronic monitoring system is checked by staff, assigned staff on a daily basis. But if something were to occur at 3 a.m, that would not be observed until the office opened in the morning. That's passive electronic surveillance. And then the more active version is the surveillance company calls somebody in the middle of the night, which then starts a cascade, basically a phone tree, which results in a response of some kind at some point. I think it's worth highlighting here, though, that if I am somebody on home detention and my intention is to go commit a crime and I cut off my ankle bracelet, nobody's stopping me at the door. I'm going to go do whatever I need to do. So this concept of it's like more active is still passive surveillance. And so we're basically saying we're not really achieving a policy aim here. Because it's so onerous on us, let's move it into the same value and framework we use for our normal surveillance monitoring, which would eliminate the need to have standby. Is kind of the and that equals that would eliminate the need to have home detention standby, which would be a major net positive for the field.
I think that sounds like a sensible option.
Well, the language is there for passive electronic monitoring. That's one good thing, Ben, you did put in. Ben, that one may stay.
Non-controversial.
We can all agree on something.
We can agree on it. Anything else to the commissioner before we shift gears here to our state's attorneys? Okay, welcome. Thank you. Stay in the room.
Yes, I will.
So we're going to shift gears to Tim. Tim, I can never pronounce your first name, Dumont, but it's Tim.
Yes, and it's Leaders Dumont, and last time I think I was in this committee, Tim Leaders Dumont from the Department of State's Attorneys and Sheriffs was when I was working for the prior treasurer, and we were talking about clean water and bonding. So,
So we may want to go back there at some point.
It's a citizen witness only.
So Tim, we're still working on Ben's draft. We have not deleted that part about the home detention being a condition of release on bail. It's been presented. We need to make that decision, but I want to hear your testimony on behalf of the Department of State's Attorneys and Sheriffs.
Thank you, and I'll try to head note some of this by saying that I think Ben's suggested change to just keep this about 7554 little b is a very good suggestion, not only because I get very nervous about playing with the bail statute for a bunch of reasons, the sort of 7554, mainly right now, just big picture, we have a tremendous backlog, and it is the operational integrity Bible handbook. 7554 is what defense attorneys, prosecutors, judges all memorize. And so when you start, just as a point of caution, when you start making changes to 7554, all of a sudden case law that has been precedent might change. And I just want to put a little bit of a head note there. But talking about this bill right now, at the point where home detention is being considered, pausing there for a second, there's already been the bail analysis. There's already been 1754 analysis, and there's already been the risk of flight analysis. So that's why there's only 9 people in this program. It's already such a serious sort of set of circumstances that Pathway has already checked off a lot of boxes. So just stopping there for a second, 7554B means that you are held on bail, but home detention is now the option that you've been given. And that's why all those 9 individuals, they were very, very serious crimes. And so in speaking with our state's attorneys, I think that we always appreciate options. And I hear the resource and the staffing concerns from Commissioner Demmel, and believe me, we absolutely appreciate that. As someone who used to have 500 cases every single day, I really appreciate that. And I think we also, like the idea of if someone is being held on bail, perhaps they have medical concerns, age concerns, family concerns, where home detention might be appropriate. Always in a case-by-case analysis, instead of making a bright line rule. The case-by-case analysis is really where this comes into play. And I used to work as the arraignment attorney here in Washington County. So I've done, I don't know, 1,000 or more arraignments, maybe more. And responsible adult home detention. These are things that are not often happening at arraignment because, for a number of reasons, take some time. Defense attorney, the Department of Corrections, or the court. Those are the 3 parties that could ask for home detention: Department of Corrections, the state, the defense attorney, or the court could say, you know what, this individual might be a good candidate for home detention. So let's look into this. And so that type of triggering event is already possible at arraignment, but it also provides, the statute already provides that at any other hearing. So let's say there's a status conference, someone's been held for 90 days, or as Representative Boslin pointed out, 4 months. At that point, the court, the defense attorney, or the department who may have limited information might say, you know what, this person might be a good candidate for home detention. And at that point, you could kick off that analysis for suitability. And I just want to also stop for a second. 1754, the bail statute, as it's been called in the chapter on bail in Title 13, Part 1 of that statute is about risk of flight. And maybe that's a bond, maybe that's conditions. Part 2 of that statute is about public safety. That has to do with the conditions of release that Representative Triano was talking about. Once that analysis has taken place, let's say bail has been imposed for a serious incident where risk of flight is present, then you can think about 1754 little b. And so hopefully that is helpful contextually. I always think it's helpful to go through hypotheticals, but I won't do that to you now, perhaps on a different day. But I really want to stress that options as an alternative to bail are always helpful. And for those 9 individuals, there's been this deep analysis at some level that's taken place despite the seriousness of their crimes and despite the violence of the potential alleged conduct, where the risk of flight is present for all those 9 people, but also the ability to have them detained at home for whatever reason, including medical reasons, might also be present and sort of counterweighing, counterbalancing some of the concerns with risk of flight. So hopefully in sum, I think we appreciate the option of home detention, even if it's sparingly used, but we also note that there are, we don't have the information that the commissioner has about the staffing and resources that it takes to be successful. So we always appreciate the options to assist somebody in coming to court. That's what this is all about. Let's get them to court.
So Tim, even though the numbers are small of folks who are on home detention, at least your feeling and the testimony is to at least keep this as a tool in the toolbox, right?
I believe that, right. In a survey of our state's attorneys, I think it's sometimes hard to get them to say something so simply, but yes, I think that's correct. And the other point I'll make is that Ben's suggested change, just make it about 7554B, little b, so that there can be that time for the suitability and then referencing the bail statute. So that way, if for some reason during that 7 days, there's, someone could say, this person has decided to join the Peace Corps and Mother Teresa is now going to be the responsible adult. Okay, so we got some change in circumstances. That happens. These things are not stagnant. And I'll say for all those 9 cases right now, every single one of those are what I call middle of the night wake up incidents. I'm getting a call as the deputy state's attorney on call. I'm concerned. The officer has told me that individual, let's say Connor Casey, my dear friend Connor Casey has committed a
Had
violent
too
act.
many pints? Had too many pints?
Doesn't sound like me at all.
As we get into
Hey,
St. Patrick's Day, something happened. And
Careful.
come on, there's other Irish in the room.
all this to say, there could be something that happens overnight. This person has failed to appear 15 times. They have 30 violation of conditions of release. Okay, this person is going to be held on bail. The incident involved was a domestic. They tried fleeing the state of Vermont that night. The officer's telling me this, so we asked for bail. Person shows up in court because they weren't able to make bail. Let's say it's $2,000 bail. The judge at that point, like I said, a responsible adult might show up at that arraignment. Often they aren't there yet. But that's when rubber hits the road. And perhaps at that point, bail might be struck. I might be there in the courtroom talking with the defense attorney and saying, maybe bail isn't appropriate anymore. And so because of those changes that you talked about, Madam Chair, $200 limit on misdemeanor bail. So if I get a misdemeanor in the middle of the night, I'm asking for, I think bail is appropriate. $200 is the limit for misdemeanor bail. So there has been changes. Presumptive diversion. So a lot of the cases historically and across the country, particularly in the Deep South, an individual might get held on bail. In Vermont, you folks have done an incredible job in creating presumptive diversion for possession cases, even simple assault cases. So there's been a huge amount of work, and that's another reason on the low end why there may not be more people involved in this program. But you've had I had so many points, I think, from hearing you folks today, that I'm really happy you're taking the time to think about this, because no one ever wants to hear from me on the bail statute or any parts of it. So I'm happy to come back to and talk about it.
So, Tim, if we were to do away with home detention, if we were to repeal the statute, as what the administration has proposed, what would occur, what would happen to those 9 folks that are on home detention now, and we repeal the program? What would then happen? We'd have to address that somewhere.
So I think what would happen, just looking at the way the statute's currently set up, is if I were the defense attorney for those 9 people, and I know there's folks with experience in that realm here who will testify in the future, but I would ask for a hearing to review bail, because they would be set for bail. They would probably be held for bail in many of those situations. But it's also possible that the court or the state's attorney might ask for, upon notification that home detention is going away, the individual is now going to be held in the incarcerative facility. There could be a request for a status, right? I mean, that would, all 9 of those cases would get a status at bare minimum. And perhaps the state's attorney could look at those cases and figure out, another option with the defense attorney. But if nothing were to happen, other than it goes away, they would all be, in my opinion, probably transferred to an incarcerative facility, all 9 of those individuals, because of the risk of flight analysis. Again, bail is only for risk of flight.
Questions? Troy?
I mostly just want to go on record that I'd be happy to be Representative Casey's responsible adult.
Thanks a lot, Troy. I was just resting in my account.
Would you agree to report any violations of his conditions?
Oh, God, I'm not the judge. Questions? Tim? Chip?
So it seems to me that if someone was in compliance with home detention for a considerable period of time, that defense attorney would have a good argument in front of a judge to release that individual on conditions similar to what they had been on previously, if the program was to terminate.
You'd have to get rid of the bail.
Yeah,
Right.
So in thinking about that, one of the potential positives of home detention is that these are individuals, as you've all noted, they're going to get credit. They are receiving credit. So because of the seriousness of these cases, I would say statistically, it's more likely that they're going to continue to interact with the Department of Corrections if they receive a conviction, because these are all just pending. If they receive a conviction, they already have potentially good interactions with the Department of Corrections, hopefully very few violations. So if I were a state's attorney, and I'm getting a report that this person has been on home detention for 2 years, we're now coming to the sentencing phase, I'm going to think this person's probably a pretty good candidate for probation or for a non-incarcerative deferred sentence, where, again, it's a form of probation where eventually it goes away if they're in compliance. So I think, if the department is well-resourced, well-staffed, and has the opportunity to be successful, in speaking with some of our state's attorneys, I can't think of a single one of them that wouldn't consider the conduct that's occurred during the home detention pendency when making that recommendation, argument at sentencing, and a judge certainly as well. A good defense attorney is going to say, my client, CC here, we'll just use initials going forward, but my client has been an absolute model citizen during the last 2 years of home detention, despite the seriousness of the crime. And
We love you, Connor.
and going forward, well, as soon as he walked in late, I had to give him some guff.
I won't come at all next time.
But I think you're right, Representative Trout. That should be considered like anything else.
So anything else? Any other questions for Tim? So we have some more work to do on this tomorrow. We have Judge Zone in, we're going to have DOC back at the table, and we're also going to have the Defender General. So Tim, if you want to join us tomorrow as well, you're more than welcome to. We're going to be looking at this at 11:30 tomorrow morning. We hope at 11:30. And we need to make a decision on this language tomorrow to make a recommendation to our colleagues in Appropriations Committee, because this repeal of home detention is in the governor's recommended budget. So.
Well, thank you. I'll be across the hall at my second home at House Judiciary, but I'll try to peel off. See you guys.
Well, we're just down the hall. We're in the committee room where Ways and Means used to be.
Okay, gotcha.
So we've moved for that.
Okay.
So anything else for Ben? Anything else for the commissioner, for Tim? Ben?
Do you want me to remove that cross-reference or that listing home detention in 7554 and just keep it in 7554 little b?
Where is the committee on that?
Is that the part about the 7 days?
Yeah, where, what Ben is suggesting, where he has put in the bail section that home detention is a condition of bail.
So it would no longer be a condition of release, but what could happen is that keeping it in the home detention statute, it would just permit during that 7-day period while the department's doing its investigation, they could be released pursuant to conditions of release. It would just no longer list home detention as
A condition,
conditions.
right. Mm-hmm. So it would be a condition based on what they normally would do with a person on bail.
I would explore that.
That would be
Okay.
good.
So I can make that adjustment.
Why don't you delete that? Keep everything else here. What I'd like to do is take a break. And I want to come back as a committee, so at least we can weigh in on the absconding part, and we can weigh in on the other pieces that we need to respond to Appropriations Committee. So if you can pull out your little sheet that looks like this. And then what I know that Tristan and a few folks have been working on some things they would like to discuss about corrections, and maybe have a committee bill, but it wouldn't meet I don't know if it would meet crossover, because we got a lot we'd have to take a lot of testimony on it. But doesn't mean we can do a committee bill after crossover. It just wouldn't be guaranteed to be work on this session by the Senate, but we get it in the hopper. Tristan has some thoughts that he's picked everyone's brains about what people are interested in. So I'd like to have that conversation this afternoon for that. So I don't know, maybe DOC if he can't stay. Maybe Isaac can stay.
Isaac can stay.
Okay.
Fortunately, I'm already quite
Yep.
late for my next meeting.
Go to your, and Isaac, as long as we got somebody in DOC. So let's take a quick 10-minute break, and we'll be back in 10 minutes at 25 of 3.
And home detention is moving to the state.
Good to see you, Ted.